Welcome to Inside the Case, where we break down what's really happening inside the courtroom, not just what's said, but why it matters. Today's episode features two different cases with pro se defendants whose decision to represent themselves leads to two sharply different outcomes. So make sure to stick around after the first hearing to see just how wildly different the second case unfolds. The first pro se defendant is Sydney Steele. In March of 2024, Ms. Steele received a citation from Lieutenant Jonathan Carey for allegedly following too closely an improper lane change. Ms. Steele entered a not guilty plea and requested a bench trial, meaning a judge, rather than a jury, would decide the outcome. The trial was held in August of 2025, more than a year later, via Zoom in Clayton County State Court with Judge Tammy Hayward presiding.
Okay, you're charged with following too close on 2024 TK 06653. You're also charged with improper lane change on case 2024 TK 06652. Mr. Tipton, are you ready to go forward with trial?
Yes, Your Honor. State's going to call Lieutenant Jonathan Carey to the Zoom call.
All right. Lieutenant Carey, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right, you can put your hand down, sir. Ms. Steele, you understand that you have the right to ask questions of any witnesses brought by the state. The state has the burden of proving the case against you beyond a reasonable doubt. You do not have to give any testimony or evidence against yourself. You have a Fifth Amendment right against self-incrimination, and the state needs to prove the case beyond a reasonable doubt. All right, do you understand?
Yes.
All right. Mr. Tipton, you may introduce your witness.
Yes, Your Honor. Lieutenant Carey, please state your name for the Zoom call.
Lieutenant Jonathan Carey.
And Lieutenant Carey, how are you currently employed?
Currently the lieutenant for the Clayton County Sheriff's Office Black Hawk Traffic Unit.
And how long have you been with the Clayton County Sheriff's Office?
The Sheriff's Office, probably a little over 2 years.
Mm-hmm. And you have prior experience before that, correct?
Yes, I was with the Clayton County Police for about 4 or 5 years.
And during that time, both with the Sheriff's Office and the Police Department, have you been post-certified?
Yes.
Okay, and being post-certified, are you authorized to investigate crimes, issue citations, and make arrests based on your investigations?
Yes, I am.
So I want to bring your attention to March 20th of 2024. Were you working for the Clayton County Sheriff's Department at that time?
Yes.
And were you on duty that day? Yes,
I was.
Did you at any point in time have occasion to make contact or initiate a traffic stop with a white Chevrolet Trax that was driven by Miss Sydney Steele?
Yes.
Okay. Can you tell me about what drove you to or what caused you to initiate contact with Miss Steele?
Yes. So during my role during the day, I look for erratic lane changes, reckless drivers, speeders. So while traveling on Bear Boulevard, passing over 48, I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that she was changing lanes, nor was she using a nor was the vehicle using a turn signal. I observed the vehicle getting closer to me as she was changing lanes. She was also following another vehicle too close. Once she changed from lanes 2 back to lane 1 several times, she passed me. I'm sorry, from lane 3 to lane 2, she passed me in lane 3, and that's when I conducted a traffic stop on that vehicle and spoke with the driver. While speaking with the driver, she advised that she was in a hurry to get to Atlanta because she had a hair appointment.
You stated she didn't use any turn signals. Is that correct?
Correct.
Okay. And what was the basis of the following too close?
She was following another vehicle too close as she was changing lanes.
Okay. Based on your knowledge, your training, and your experience, as well as what you observed, was that a safe maneuver for her to make?
No, it was not.
Would a reasonably prudent driver have followed that closely?
No. And if that vehicle in front of her would have slammed on the brakes, she would have been at fault, and that definitely probably would have caused an accident.
Okay. And with the improper lane change, was there anything improper? Tell me about what was improper about that lane change besides just the signal.
So when you change lanes, you have to give the public enough notice that you're about to change lanes. which she failed to do
Okay.
several times, not just one time.
Okay. So about how many lane changes did you observe?
I believe I observed 3. So she went from the number 3 lane to the number 2 lane, then back to the number 3 lane.
To current Clayton County?
Yes, it did.
Okay. I have no further questions at this time.
All right, Ms. Steele, did you have any questions of Lieutenant Carey?
Yes.
Go ahead, ma'am.
So you said that you were observing me in your rearview mirror when I
Correct.
did all of these okay. So if you're observing me in my rearview mirror, how are you able to see how close I'm driving behind another car? If you're looking in your rearview mirror, you would see the car that's in front of me. You wouldn't be able to see my car.
I can see your car and the car in front of you.
Got you. So how are you able to determine how close my tires were to the trunk of the car in front of me?
I can't determine how close your tires are, but I can determine how close your bumper is to their rear bumper
And how are you able to do that?
by looking at it.
And what did you see? How close was I, if you had to guesstimate?
You're less than a car length behind them.
Less than a car length?
Correct.
And this was another car and this was not your car?
Correct.
Okay. I don't have any more questions for you.
During questioning, Lieutenant Carey testifies that he was able to observe Ms. Steele following another vehicle from his rear view mirror, estimating that she was less than 1 car length behind the vehicle in front of her. Under Georgia law, drivers are prohibited from following another vehicle more closely than is reasonable and prudent, considering the speed of traffic and roadway conditions. In the 2009 case, Proctor v. State, the Court of Appeals of Georgia held that an officer had sufficient grounds to initiate a traffic stop when he observed a driver traveling approximately 1 car length behind another vehicle at highway speeds, concluding that if the lead vehicle had made an abrupt stop, there's no way the driver could have avoided a collision. Accordingly, Lieutenant Carey's testimony that Ms. Steele was following less than 1 car length behind another vehicle could, under Georgia law, be sufficient to establish a traffic violation.
All right, anything else, Mr. Tipton?
Briefly, Your Honor. Lieutenant Carey, was your view of the car immediately in front obstructed?
No.
Was your view of Miss Steele's vehicle obstructed?
No.
Which lane were you in, sir?
I was in the number 2 lane.
Okay. And which lane did you observe the vehicle in when it was following too close?
Number 3.
Okay. Would you say that?
Well, when she was falling too close, she was in the number 2 lane as well.
Okay.
She went from number 3 lane to the number 2 lane, followed the car too close, and then switched back to the number 3 lane.
Okay. Were there multiple cars that she followed too close to, or just the one?
Just the one.
Okay. Okay. And so you had an unobstructed view of her front bumper and the rear bumper of the car immediately in front of her, correct?
Correct, by using my side mirror at the time.
Okay, awesome. Thank you. No further questions.
All right,
I do have just one more question.
go ahead.
What was the kind of car that I was driving behind?
I'm not sure.
After Ms. Steele finishes her cross-examination, the state conducts a brief redirect of Lieutenant Carey. During that redirect, Lieutenant Carey changes a key detail of his testimony. He now states that he observed Ms. Steele's front bumper and the rear bumper of the vehicle ahead of her using his side mirror after previously testifying that he made those observations through his rear view mirror. Ms. Steele follows up with a simple question. What kind of vehicle was she allegedly following too closely? Lieutenant Carey admits that he doesn't know. Ms. Steele's questioning appears to be a deliberate effort to highlight inconsistencies in Lieutenant Carey's account and to test the reliability of his recollection.
Do you remember the color?
No, I don't.
Okay. I don't have any more questions.
All right. Did the state have any additional witnesses to present?
No, Your Honor. State's going to rest this time.
All right, Ms. Steele, did you wish to present evidence and testimony?
Yes.
All right, you understand that you're not required to present any evidence or testimony?
Yes.
All right, you're waiving your right to remain silent in order to offer evidence and testimony?
Yes, ma'am.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Go ahead, tell me what you need me to know.
Okay, so the day this happened, I stopped at the gas station. At the time, I was 6 months pregnant. I stopped at the gas station, grabbed some water. I get out of the gas station. I turn right. As soon as I turn right, I turn into a light. I pulled behind the police officer. No other car was in front of me other than the police officer. When the light changed, it's like he wasn't moving. So I put my signal on to get in the lane to the right of me. I got in the lane to the right of me. He then got in the lane behind me. And I looked in my rearview mirror and I'm like, he is driving so close to me. Like, he was so close. I could not see his tires. This is why I asked these questions, because in driver's training, they teach you have to at least be able to see the car's tires behind you. So that's how I was able to determine that he was driving too close to me. It was not a car length behind me. So then I'm like, okay. So I put my signal on, get back in the left lane. He gets back in the left lane. So I'm like, what is happening right now? Like, I was so confused as to what's happening. I'm like, am I in his way? What's going on? So then I did get back into the right lane. And when I went to get into the right lane, that's when he turned this light on and pulled me over. And I was confused as to, one, why he chose to do that. Because like I said, I was just confused. And he asked me, I asked him, why did you pull me over? And he said, are you in a hurry or something like that? And I was like, well, I'm trying to get to my hair appointment because I was going to get my hair done for my baby shower. And he's like, okay, and then asked for my information. And when he came back and told me, one, driving too close, I'm like, how was I driving too close when I pulled up behind you at a red light? So I literally was not driving. You weren't driving. The light was red. And then when the light changed colors, you didn't really take off. So I'm like, okay, let me get out of this man's way because I have somewhere I have to go. And clearly he does not. So that's when I got over. And also, I have a 2024 Chevy Trax. My car, you literally cannot switch lanes without putting your signal on because it will jerk you back into your lane. So for one, I don't change lanes, especially while I was 6 months pregnant, without giving anybody proper notice, because I wouldn't want to put myself or my son in danger. And then that's why I also asked, what was the car? Because, there literally was not another car in front of me other than him. And then when I got over, for him to see all of these different lane changes, he was right behind me. And I did switch lanes that many times because he was driving so close up on my bumper to where he was correct. If I would have put on my brakes, he would have hit me in the back of my car.
Any questions, Mr. Tipton?
No, Your Honor.
All right. Anything else, Ms. Steele?
No, ma'am. No, Your Honor.
Okay. Argument?
State will submit on the facts, Your Honor.
All right. Ms. Steele, I found you not guilty of the offenses before the court. Each of you are given testimony in this case. Each person has submitted sworn testimony without additional evidence. Neither testimony has greater weight than the other. Therefore, the court is not able to determine beyond a reasonable doubt that you committed an offense in this case and finds you not guilty on both offenses.
Thank you.
You're welcome.
After hearing Ms. Steele's testimony, the court is left with two competing versions of events. After cross-examination revealed inconsistencies and gaps in Lieutenant Carey's story, the court concludes that the state has not met its burden of proof beyond a reasonable doubt and finds Ms. Steele not guilty on both charges. Let's now look at a second pro se defendant whose hearing takes a dramatically different turn. In this case, Michigan defendant Cody Lee Jolly appears before Judge Simpson on a felony charge of assaulting a prison employee. Prosecutors allege that on August 10, 2024, while housed at the Washtenaw County Jail in Pittsfield Township, Mr. Jolly struck a corrections officer during meal service inside the facility. The charge carries a potential penalty of up to 5 years in prison, a $2,500 fine, and court costs. Like Ms. Steele, nearly a year later, on August 4, 2025, Mr. Jolly appears in Washtenaw County District Court for a preliminary examination, where the court must decide whether the prosecution has presented enough evidence to send the case forward to circuit court. Mr. Jolly remains in custody and has chosen to represent himself during the proceeding.
There's great peril in representing yourself You need to be aware of that. The court won't treat you any better, won't treat you any worse by you representing yourself. I would further advise you that if at any point you wish to be represented by an attorney, then you should let the court know at that point. And I will do my best to arrange that you have an attorney to represent you. You understand that, sir?
I do.
At this stage, the court is not deciding guilt or innocence. Instead, the focus is on whether probable cause exists, and that determination will rest almost entirely on the testimony of a single witness. With that, the state calls Officer John Apple.
All right, you may inquire.
Thank you, Your Honor. Sir, how are you currently employed?
I work for the Washington County Sheriff's Office and the Corrections Division.
And how long have you worked in the Corrections Division of the Washington County Sheriff's Office?
Approximately 18 months.
Okay. Were you working in that capacity of August of last year, 2024, specifically August 10th?
Yes, sir.
Okay. And you were working in the Washington County Jail? What's your shift on that time, on that day?
I believe it was noon shift. It was 3 o'clock to 11.
3 p.m. to 11 p.m.? Okay. Directing your attention to around 5 o'clock in the afternoon or early evening on August the 10th, 2024, what were your job duties in the Washington County Jail at that time? What were you doing?
I believe at that time we were doing our meal pass, make sure everyone gets dinner for the night. In the specific housing we were at, that was a door-to-door feeding unit. So you work with a incarcerated individual, worker, or trustee. You go door-to-door do meal pass.
Okay. And what specific block or area of the jail were you working at that
I was
time?
working at A block that also has our max housing unit and observation unit.
So it has max housing observation unit, and that is within the A block of the jail.
Correct.
Okay. And you said you were passing out dinner effectively?
Correct.
Okay. Are you familiar with an inmate by the name of Cody Jolly?
I am, sir.
Was that individual housed on that block at that time?
He was.
Okay. I don't know, Your Honor, is the screen that in front of Officer Apple the same screen that we're seeing, or is that screen black?
It should be this.
Okay.
Well, no, he is. Yes, he is seeing what we're, I guess, primarily that the one that's moving.
Okay.
Is the one that he's seeing. Right?
Officer Apple, can you identify anyone on the screen in front of you that you recognize from that date of August 10th, 2024?
I can't, sir. I see an incarcerated individual, Cody Jolly.
Okay. And can you describe what they're wearing on the screen so we know who you're talking about?
Orange pants and a white long sleeve t-shirt.
Thank you. Your Honor, may the record reflect identification of defendant Cody Jolly.
Record shall so reflect without objection.
So Mr. Jolly was housed on A block and that's where you were passing out meals on August the 10th of 2024?
Yes, sir.
Okay. What, if anything, occurred when you had an interaction with Mr. Jolly on that date and time?
When I approached his door and breached his door to pass him his dinner for the night, he asked me if he could have another tray. He was sitting on his bed in the unit at the time. I told him that, if I have any extras, I'll circle back to him. And when I turned to collect the beverage for him, he began to stand up, and I believed that he was coming to approach me to grab his drink. But at that point in time, he began to strike me in my head and face area. We got in a bit of a scuffle. I tried to gain control of Mr. Jolly. He kept delivering strikes to me. So I delivered strikes back in self-defense. Was able to gain control of Mr. Jolly to the point where I could get back to my radio and essentially call for backup. In the jail, we called an available officer call.
Okay. And I'm going to just unpack that a little bit, Officer Apple. So you passed Mr. Jolly his tray of food,
Right.
and then you had turned to retrieve the beverage from the cart.
Right.
And where was that cart located?
It was just off to my right, so it was almost right in front of his door. I had an inmate worker helping me pass trays at the time, so I turned to him to get the cup. As I faced Mr. Jolly, he began to stand up. Like I said, I believe he was coming to meet me halfway for the beverage, and he began to strike me.
Okay. Other than yourself and the inmate who was assisting you, were there any other corrections officers in that area at that time?
No, sir.
Okay. Did Mr. Jolly say anything to you as he stood up and began, I guess, to kind of advance towards you?
No, sir.
Okay. You said he struck you in your face.
Right.
Do you have any idea approximately how many times?
3 to 4 times.
Okay. Do you recall, was that closed fist, open fist, slap? Can you give us any detail?
Close fits. It was kind of towards the top left side of my head and my face.
And
my glasses off.
okay, so kind of, you said left side of your head, above your eye. Is that a yes?
Yes, sir.
Thank you. After he struck you a few times, you were able to basically strike him back in self-defense and eventually get control over Mr. Jolly. Is that fair to say?
Yes, sir.
Okay. Did other jail staff respond to assist?
Once I got control of Mr. Jolly and was able to get back to my radio, during the scuffle, I got knocked off as well as my glasses. So I was on top of Mr. Jolly at the time, was able to recover my radio and get that call out, and then other officers did respond.
Okay. Did you suffer any sort of injuries from this?
Superficial injuries, bruising, soreness, no long-term surgical. And I did get sent out to St. Joe's at the time, or the Trinity Health emergency room, and then I had to do a follow-up, make sure I didn't have a concussion or anything before I could return to work.
Okay.
Officer Apple testifies that during dinner service inside the Washtenaw County Jail, Mr. Jolly stood up from his cell and struck him multiple times in the head and face, leading to a physical struggle and a medical evaluation to rule out a concussion. Mr. Jolly is charged under the Michigan Penal Code Section 750.197C, which criminalizes assaults committed by inmates against employees of a place of confinement, such as a correctional facility. Under that statute, the state is relying on Officer Apple's testimony to show that the defendant was lawfully imprisoned and that the defendant used violence, threats of violence, or dangerous weapons to assault an employee. With the officer's account now on the record, Judge Simpson turns to Mr. Jolly to ask whether he intends to present evidence of his own. But it quickly becomes apparent that Mr. Jolly is struggling to understand where this hearing fits within the larger criminal process and what's supposed to happen next.
Mr. Jolly, do you have any witnesses that you'd like to call?
I do not. Just to remember, this is pre-trial, correct?
Well, it's a preliminary examination, Mr. Jolly.
Okay. All right. I was told it was pre-trial, led to the last court date, and then you told me you were rescheduling it for pre-trial, and so I don't know where we're at in the process. It was my understanding these last two have been pre-trial.
No, they were PCC and then your preliminary examination, sir. And today is your preliminary examination.
Okay, so okay. So what is my next one then?
Well, I don't know yet. Do you have any witnesses that you want to call today?
No, I do not. I just
okay. Do I have a motion?
So Your Honor, my question was that it's been over a year and I'm just trying to get to pretrial. And my understanding was that these last two cases were both pretrial. It's been over a year. And for some reason we still haven't got to pretrial yet. Can I ask you why?
Well, I can tell you that you had a competency evaluation that there was an issue with you participating in. And then there was always the issue of your participating in all of the proceedings as they were set. So the matter could not move until there was a motion that was filed by the people, given your reluctance to participate.
Okay, well, that motion was.
So Mr. Jolly, I'm not going to sit there and argue with you. I'm here now with your preliminary examination. You don't have any witnesses. Do I have a motion from the people?
Yes, Your Honor. At this time, people would move to bind the defendant over as charged on the one count before the court.
Mr. Jolly, do you have a response to that?
I didn't hear him. Could you say it one more time?
Pardon?
I didn't hear what he had said.
Your Honor, the people would move to bind the defendant over on the one count before the court and ask this matter proceed to circuit court for further proceedings.
Do you have a response, Mr. Jolly?
So, okay, my response is to move it to circuit court. We're talking about conference then. Is that correct?
Pardon?
Or if we move it over to circuit court, then we're on to conference. Is that correct?
On to conference?
Is that, yeah, he just said move it to circuit. Does that mean we're on to conference? That was my understanding, is that we're moving to conference. That would also be my request too.
Well, I don't know what you're trying to say. All I know is that what the people have asked is that the matter be bound over to circuit court for you to stand trial there.
Right, which would be moving from here to conference, which is right before trial, correct?
You would have different proceedings before Judge Slay, yes.
Which would probably be conference, am I correct?
Sir, you will have different proceedings before Judge Slay.
Okay.
Do you have anything in response to the people's motion to bind over?
You know, I would prefer, my response is to prefer to move on to conference. That would be my response to that. And then I also have my own, I would like to request again. I put in the motions for jury trial, a 12-person jury trial. And I also put in my motion for the 45-day speedy trial. And I am also requesting those as well again here today.
After declining to call any witnesses, Mr. Jolly suggests that his case has been unconstitutionally delayed. More than a year has passed since the alleged incident, and he expresses frustration about what he sees as a lack of progress. The right to a speedy trial is a constitutional guarantee. The Sixth Amendment provides that, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Michigan's Constitution contains a parallel protection guaranteeing criminal defendants the right to a speedy trial under Article 1, Section 20. But what exactly does speedy mean here? Well, in the landmark U.S. Supreme Court case Barker v. Wingo, a murder suspect was not brought to trial until more than 5 years after his arrest. Even so, the court held that his speedy trial rights had not been violated. Rather than adopting rigid time limits, the court established a balancing test that weighs 4 factors: the length of delay, the reasons for the delay, whether the defendant asserted the right, and whether the delay actually prejudiced the defense. Under that framework, speedy trial claims are evaluated case by case, not by the calendar alone. Proceedings such as competency evaluations, motions, or a defendant's own conduct can all affect the length of a criminal case and how a court weighs a speedy trial violation claim. As Mr. Jolly presses the issue, he appears to be struggling to understand how this hearing fits into the larger criminal process.
All right. The court has heard the testimony in this case from Officer Apple. The court does believe that the people have indeed sustained their burden of showing that the defendant was in a place of confinement, that he also then assaulted an employee of that place of confinement. And so for those reasons, the court would bind the defendant or find that the people have established probable cause that this offense was committed and that the defendant committed it, and the defendant would be bound over to circuit court to stand trial. Jolly, you're now proceeding into what will be your circuit court arraignment.
Right.
I've bound you over to stand trial. I'm now going to conduct your arraignment regarding those proceedings. So I would advise you are before the court on a complaint that alleges that August 10th, 2024, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Washtenaw County Jail, that you did, being a person lawfully imprisoned in the jail, did assault a John Apple, who was an employee of a place of confinement or other custodian, knowing the person to be an employee or custodian, through either the use of violence, threats, violence, or dangerous weapons while you were awaiting trial, contrary to Michigan statutes. Do you understand what you are charged with, Mr. Jolly?
I understand what I was charged with, to do.
Okay, that is a felony. It is punishable by up to 5 years incarceration and a $250 or $2,500 fine plus court costs. You understand that, sir?
I understand that.
All right. I do also have to advise you that if you are convicted, law enforcement is to collect a DNA identification profile sample before sentencing or disposition if it was not taken at the time of arrest. You understand that, sir?
Yes, I do.
All right. How do you wish to plead to that charge, sir?
No, not guilty. I also.
All right. The defendant, having heard reading of the information, pleading not guilty, court will enter that plea. A pretrial in this matter will be set for
September 25th at 1:30 for Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Okay, my request for jury trial and speed, I requested a speedy trial already, and I did file these motions. Now, can you, is this where I bring this up again? A speedy trial.
You can bring those up before Judge Slay.
I've already requested it before you, though.
I know.
So
And what I'm indicating is that I am not making a ruling on those because I don't have to. First of all, in regard to any delay in these proceedings, Mr. Jolly, you were the cause of the delay. So I think that any reference you're having towards speedy trial,
there's a right to speedy trial.
it's really your issue. Your issue to a trial by jury is intact. You will have your trial by jury if that's what you wish. Again, you may raise all of these issues before Judge Slay.
I did request a 12-person jury also.
In circuit court, that's the way it rolls.
And so that's the way it goes to the speedy trial. I don't have what you're saying. I don't have a right.
You can raise that if you think that you have been denied that. My ruling is that there has been no violation of any right you have to a speedy trial, because any delay that has occurred in these proceedings is either an acceptable delay in terms of the competency, but also any other delay was a result of your conduct.
It was 30
that
days
delayed
ago
these
on my
proceedings.
request, Your Honor.
Mr. Jolly, I'm not going to sit here and argue with you. I'm telling you what my ruling is. You may raise that issue again if you like before Judge Slay. You will get your jury trial. That will all be set before Judge Slay, and you'll be able to proceed there.
So
at this time, these matters having concluded, your bond is continued. Thank you.
Judge Simpson rejects the speedy trial argument after determining that the delays were attributable to Mr. Jolly's own conduct and binds the case over to circuit court. Court records indicate the case is set for a jury trial, and we'll keep you updated on the outcome as we learn more. Today's two hearings show how sharply outcomes can diverge based on factors other than the allegations themselves. If there's a case you'd like us to take a closer look at, let us know in the comments, and thanks for watching.